putting this into a little bit of context. So, as you probably all know, we are celebrating the 100th birthday of the National Park Service. And one of the things we've decided to do here at FNES to celebrate that is do a series of panels addressing issues within this space, but in sort of typical FES fashion, we've decided to really overshoot and do something much broader than necessary. So instead of just national parks, we're doing public lands across the board. Now you may read this and think, all right, energy development on public lands, that also is a broad topic that's going to cover a lot. When Lisa and I started talking about this panel, we actually thought of this as a very significant narrowing of what this conversation could have been about. So we had initially talked about having a panel on just conflicting uses of public lands, which is obviously a huge topic that even in, what do we have, an hour and a half, I'm not sure how much time we have, but in whatever amount of time it is, we could not have gotten through. So we hope that this is a narrow enough subject that we'll be able to sort of hone in and focus on something interesting. Energy, obviously, is one of the most contentious, interesting issues on public lands across the US. So that's the sort of point of gravity that we want to start focusing on. So let me introduce Lisa Dale, who is going to be moderating the panel and making sure this all runs smoothly. So Lisa is the Associate Director of the Yale Center for Environmental Law and Policy. It's the second most important job in all of the university. She comes to us from Colorado, where she worked in government for, over a decade.
5 years.
Under a decade. But she was in Colorado for over a decade.
25.
She received her PhD out there, did some incredible work, and then came to us to bring some more Western skills and experience to this little southern New England town. So Lisa, thank you very much for doing this. Everybody else, thank you for being here, and everybody enjoy.
Thanks, Josh. Can you hear me? I think I have all my wiring on correctly. So I'm Lisa Dale. I'm pleased to be moderating this panel. I want to say a couple of words quickly about the topic. I think Josh set us up really well. So when we talk about energy development on public lands, I just want to break out some of those terms so we're making sure we all know what this topic is about. By public lands, what we mean are federally managed lands in the West. And all of the states in the West have a tremendous amount of public lands that are managed by the federal government. They're managed by the Bureau of Land Management, by the U.S. Forest Service, and by the National Park Service, most notably. There are a couple of other agencies that sometimes get involved. In this conversation, we're mostly interested in U.S. Forest Service and Bureau of Land Management lands. So BLM and Forest Service lands have unique situation when it comes to oil and gas development, as well as renewables, and we'll touch a little bit on renewables. I think most of the controversy and interest in this issue comes from oil and gas development on public lands. And by development, we mean bidding for access, locating the minerals, getting them out of the ground, and getting them to market. So we're going to be talking about all of those steps along the way. So I'll begin by briefly introducing our panelists. I'll just tell you who we have here, and then I'll give them each a chance to tell us a little bit more about themselves and their areas of expertise on this issue, and then we'll jump into a conversation. So 3 out of the 4 of these panelists are Yale alums, so that's an extra special treat for us here. So sitting next to me is Monica Ehrman. She's an associate professor of law at the University of Oklahoma, and a Yale Law School graduate from 2014. Next to her is Michael Saul. He is a senior attorney at the Center for Biological Diversity, and he is a Yale College graduate from '94 and a Yale Law School graduate from '98. And next is Brandy Collender. She is in the middle of transition from the Department of the Interior to a new position, and she'll tell us about that. And she is an MEM, so an FES graduate from '07, so she knows quite a few people around here. And at the end of the table is Kathleen Stacks. She's the Assistant Director for Energy for the Colorado Department of Natural Resources and a former colleague of mine, so it's a pleasure to have her here. I'll now turn it over to them, and we'll go down the row, and they can each spend a couple of minutes telling you a little bit about the work they do on this issue and where their areas of expertise lie, and then we'll get into it.
Okay, can everyone hear me all right in the back? Great. Lisa, Josh, thank you so much, FES, YSELP, so nice to have these panels. My name is Monica Ehrman. I'm a professor at the University of Oklahoma, as Lisa mentioned. I started off in oil and gas. I grew up in Canada, in Alberta. My first internship was with Enbridge Pipelines when I was in grade 12. I have a petroleum engineering degree from the University of Alberta, and I practiced in the upstream gas storage, midstream pipelines, and even did some energy risk management before Enron came along. So that was kind of the end of that. But after that, I went to law school. I worked for a national law firm doing oil and gas litigation, and then went in-house to work for an independent oil and gas company doing transactional work, litigation, whatever company needs doing, and then transitioned to become general counsel of a privately held, non-operator oil and gas company. I did my master's of law here at Yale, which was phenomenal, and was an RA for YSALP under Josh, so that was fantastic. And then started teaching in 2013 at the University of Oklahoma. Well, 2014, I had a baby, 2013. So, but 2014, I've started teaching. I teach in the oil and gas program, the energy program. I teach water law, energy law, oil and gas law, and that's have taught and teach international petroleum transactions. I've taught in the executive MBA school at Price College, and I write in the area of oil and gas where science, technology issues kind of meet the legal sphere, so seismicity. I write in policy, so international energy policy, and also just in real property issues that involve oil and gas.
Hi, I am Michael Saul, and I'm a graduate of both Yale College and Yale Law School. But following law school, I found my way out to the west to Colorado and our abundant public lands there, where I have practiced primarily in the areas of public lands law, administrative law, and wildlife and endangered species law. I started out with the law firm of Arnold and Porter, doing a combination of natural resources law, mostly representing both ski areas and Indian tribes. Then actually moved over to the National Wildlife Federation, which Brandy has just joined, where I worked for approximately 10 years, dealing with a variety of federal public lands, resources and wildlife management issues, both in litigation and in more collaborative capacities. But since 2014, I have been pretty squarely on the conflict rather than collaboration side with the Center for Biological Diversity, where I have the privilege to work on the intersection of public lands and climate law, and what has found itself known as the Keep It in the Ground movement to end fossil fuel leasing on federal public lands and waters.
Thank you, Michael. Brandy Colander, graduate of the Forestry School. Also a lawyer, went to Vermont for law school, and UVA, where I studied government, and also was in the architecture school doing urban and environmental planning. And I think that's really where I started to sort of educate myself on the cross-section between natural resource dependence and sort of the built landscape, urban development, how we live, structures. And then was also introduced to a professor there at the time, Timothy Beatley, who sort of traveled the world and introduced us to green roofs and the sorts of infrastructure that I think today we take for granted. But now I have recently transitioned from the administration, and I had the good fortune of holding two posts while I was there. The first was as the Deputy General Counsel with the White House Council on Environmental Quality, which was incredible for a lot of reasons, but primarily because it gave me the opportunity to understand the equities of all of the federal entities within the federal family. And CEQ is sort of deemed as the keeper of NEPA. So you're often in a very collaborative posture with different stakeholders, industry, NGOs, state and federal governments. And then I recently transitioned out of, but was with the Department of the Interior, and I was a Deputy Assistant Secretary there for Land and Minerals Management. So Interior is one of those unique federal agencies. It's sort of a misnomer. It should probably be called the Department of Energy, frankly. It's got lots of different things under its umbrella, including USGS, the 4 energy development bureaus that were the ones that reported to our office directly. So that's the BLM, the 2 sister agencies that came from MMS, BOEM and BESI, and then the often forgotten Office of Surface Mining Reclamation and Enforcement. So BLM and OSMRE are both responsible for a lot of mineral extractions in coal. I think I'll leave it at that just to keep us moving. Yeah.
Great.
Actually, no, sorry. And I recently joined the National Wildlife Federation, so sorry.
It's okay, I get more time.
As an Associate Vice President for Natural Resources and Energy, so giving me a great chance to do some fun and exciting work from the outside. Okay, thanks.
Okay. My name's Kathleen Stacks. I'm the Assistant Director for Energy and Minerals with the Colorado Department of Natural Resources, and I am the Yale outsider, so bear
Always
with me.
welcome.
Thank you. I feel very welcome, so I appreciate that. My job primarily is to work on energy and mineral policy, both with the governor's office and our 2 regulatory agencies within the state that develop and enforce our rules and regulations regarding oil and gas and mineral development. As part of that, I do a lot of work with federal stakeholders. I do a lot of work with local governments, concerned citizens, environmental groups. I really have the opportunity to work with kind of all of the above. My job is mostly management of relationships and making sure that we've reached out to who we need to reach out to and engaged the people that are concerned about the things that we're doing. Prior to coming to the Department of Natural Resources just over 2 years ago, I also had a baby. Started this job at 9 months pregnant.
Well
Which I
done.
told them they were on notice, but before that I was working in land conservation for about 8 years, running an open space grant program that funded conservation easements and fee acquisitions across the state, really focusing on landscape scale conservation, providing even urban opportunities, some smaller agricultural pieces, and really maintaining our lands across the state in perpetuity. And so I have those sort of angles in public lands management and the intersection of different land uses. So I'll stop there.
Terrific, thank you. I think we'll start this panel with some of the nuts and bolts so that we can all get our arms around how oil and gas development, energy development, renewables, and coal are managed on public land. So I'm going to ask our panelists, we have a few questions prepared that we're going to use to start the conversation. We'll have at least 30 minutes at the end for questions from the audience. So please make a note if you have a question that you want to follow up on. We'll take the first 45 minutes or so of this conversation to just allow a conversation to flow, and then we'll open it up to questions. So we'll try to hold your questions if we can. So I'd like to ask our panelists to talk a little bit about the regulatory and statutory framework that's in place now on public lands for energy development. Which pieces do we have that provide the key guidance to public land stakeholders, so energy companies, cities, land management, conservation groups, local governments? What is the framework of legal and statutory regulatory guidance that is currently in place? And I'd like to start with Kathleen, because she works directly in that space, and then we'll turn to others for additions or changes.
So in Colorado, as we've talked a little bit before, we're about 36% of the state is federally managed. And so particularly on the western slope, there's a lot of land that is subject to a sort of tiered system of regulations, starting at the federal level, dealing with leasing. If there's federal minerals, we have a lot of split estates where one entity owns the minerals and another entity owns the surface. Oftentimes on the federal lands, the federal government owns the minerals as well, but we also have private lands where minerals underneath are owned by the federal government too. And so there are necessarily federal actions that need to be taken, and whatever company goes in to lease those minerals, whether it be oil and gas or coal or whatever the mineral it is, they have to go through an environmental impact statement process and get the NEPA process done before they can even lease those minerals. Then they have to go through the permitting process at the federal government level and then at the state level as well. So we have a permitting process through the Colorado Oil and Gas Conservation Commission and a mining permit process through the Division of Reclamation, Mining and Safety. And that the mining side of it really is focuses a lot on the reclamation plan, and so what they're going to be doing once they're done mining, and have a very detailed plan for putting that land back into some kind of natural use. The oil and gas regulations that we have, Colorado is really considered a leader in the nation for the protections that we have set up for things like air emissions and groundwater protection, groundwater monitoring. We have a lot of very detailed rules about casing and where you have to have your cement to protect all of the groundwater sources, and everything varies depending on where you are as well. We have rules set up that require consultation with the Colorado Parks and Wildlife if you're in any sort of sensitive wildlife habitat area, to make sure that if there needs to be timing restrictions on when you can actually conduct your activity, that those operators are taking those into account as they're developing their drilling plans. We have consultations with the Department of Public Health and the Environment. If a community is concerned about potential impacts to a drinking water source, or even just the proximity to a school, for example, we can bring in the Department of Public Health and the Environment, and they can do a consultation that'll identify some of the impacts and then sometimes suggest best management practices, or even say, this is really not a good place for this development. We need to try to find somewhere else to put this. And so we have those levels when it comes to the federal and the state levels. We also bring in the Department of Public Health and the Environment also has air quality permits. We've got some very strict air emissions rules in Colorado, and operators have to comply with those. And then on top of that, we have local governments have land use authority over mineral development. And so local governments have certain areas that they can regulate in. We actually had a decision in the state Supreme Court earlier this summer addressing the extent to which local governments can regulate oil and gas development in particular, and restricting it quite a bit, saying that really it's the state that has primacy over oil and gas development. But when it comes to land use issues, and actually I've heard vastly varying interpretations of the Supreme Court decision already. Some in industry will have you think that anything related to oil and gas regulation at all is in the state's hand, and operationally preempts any local government from doing any sort of regulation when it comes to oil and gas development. I think many others view it slightly less broad than that. But certainly when it comes to things like traffic and access, some of the nuisance issues like noise and dust and those kinds of things can fall within the purview of the local government. And so any sort of energy development that is happening in a county, sometimes counties have to require an extra permit. And so certainly federal lands are falling within county jurisdictions, and so operators and energy developers have to account for those levels of permitting as well. And I'll leave it at that and make sure that everybody else has time.
There's a lot in there. It's a good overview. I think I kind of want to just distill it at the federal level. The national, NEPA is sort of the core construct that I think every operator has to think about, whether it's their EIS development, collaboration with external stakeholders.
Just remind people to spell out acronyms so people don't know what those are. Thanks.
This is the National Environmental Policy Act.
Thanks.
And at its core, it's where environmental impact statements, it's the process for which we review the impact of large-scale infrastructure, oil, gas, coal, mineral extraction projects. Recently, the Council on Environmental Quality moved forward with a new guidance document, and this has been a long anticipated document that kind of gives a little bit more color as to how NEPA should be interpreted with respect to some of the things that are in our discourse today around climate. What that will ultimately require is bureaus, including BLM and OSMRE, they will likely then need to digest that and come out with their own version of a, again, guidance document. So I think what you've initially set forth is really helpful because it demonstrates that there's a lot of latitude around interpretations, and frankly, then that will lead to litigation before we understand exactly what the black and white rules are. And I'm sure Michael can add some color to that as well. I think when we're talking about what's happening today in terms of sort of statutory trends, the issue of primacy that was mentioned is an important one. I think there is a federalism dynamic that goes beyond just any statute. We saw this in the activity on BLM lands with the Bundys, and I think there is an interest in figuring out how to keep public lands in public hands, if you will, that is going to be an evolving conversation. And I think that's really what I would want to leave this group with as you're thinking about issues of interest, as you're thinking about spaces in which you'd like to play in the future. I think that's going to be an increasingly growing space that's going to require a lot of collaboration. And as we think about the types of resources that we will rely on in the future, I would just encourage this group to think about how to effectively use the existing regulatory and statutory tools that we have to be able to advance those projects. So I'll leave it there.
Thanks. I'm going to try and avoid the use of too many acronyms, although in this area that's very difficult to do because we have so many statutes that we typically talk about by means of an alphabet soup. Brandy, I'm going to respectfully disagree with you on one thing, which you said, which is I don't think it's accurate under the statutes to call the BLM an energy development agency. I think many people at the agency perceive that as their sole role, but the BLM actually operates under a combination of statutes, including the Mineral Leasing Act of 1920 and its amendments, but also the Federal Lands Policy and Management Act, the Multiple Use Sustained Yield Act, the National Environmental Policy Act, which Brandy mentioned, and another statute that overlays the operation of all of these is the Endangered Species Act, which requires action agencies such as BLM or Forest Service to consult with the Fish and Wildlife Service on the effects of their actions on threatened and endangered species listed under the ESA. And I'm going to take a slightly different perspective on what these statutes mean. The Federal Land Policy and Management Act plus the Mineral Leasing Act essentially set up a three-phase process for fossil fuel development, oil and gas, coal, and if the worst comes to pass, oil, shale, and tar sands on public lands. And that is planning, leasing, and permitting. And the planning stage is where the Bureau of Land Management and or the Forest Service, this gets very complicated because the Forest Service has separate statutes and a separate planning process, but it also has a, in my view, highly underutilized concurrence power under the Federal Oil and Gas Leasing Reform Act that under our National Forest Service, the BLM leases oil and gas, but they have to have the Forest Service's permission, which largely but not exclusively has been given carte blanche. I think the Forest Service is starting to re-examine that in some cases. These land use plans make very broad aspirational goals for areas encompassing millions of acres. Generally, allocate almost everything, with some very small exceptions, as open for oil and gas development, whether under what's known as standard stipulations, which is sort of anything goes, or in some cases, particularly now, since many of the interior west plans have been amended to address the threat to greater sage grouse, with some restrictions on essentially the timing and precise location of surface facilities. Then the third phase is permitting. Once a lease is issued, and just some sort of very, very basic background, these leases are initially for 10 years, but once somebody drills a producing well, or once the lease becomes part of a larger drilling unit, it becomes held by production, and the lessee essentially has a property right to extract oil and gas from federal lands as long as that production continues in paying quantities. The third phase is approval of what are called APDs, applications for permits to drill, which are either done individually or sometimes Wyoming BLM calls them collectively plans of development or pods. Theoretically, each of these stages, the land use planning stage, the leasing stage, and the drilling permit stage, are all subject both to the environmental analysis or environmental impact statement requirement under the National Environmental Policy Act, and to the consultation requirement of the Endangered Species Act, which in extremely important development, the just finalized CEQ guidance has finally made it explicit that this analysis includes consideration of greenhouse gas emissions and climate impacts, and importantly, includes life cycle analysis of those emissions. In other words, not just the emissions from the operation of the drill rig or the coal mining equipment, but emissions all the way down the line in gathering, processing, transmission, and ultimate combustion. But my view is this, is that to date, and we will see if the CEQ's guidance starts to change this, the agencies have largely played a sort of climate denial shell game with this three-stage process. In that, for a while, until courts said they couldn't, the agencies tended to say that climate change is too uncertain, or any given activity is too insignificant a share of the national or global greenhouse gas burden to think about. But what sort of has started to happen now, and again, we'll see if litigation and or the CEQ changes this, is at the planning stage, the agencies tend to say, well, we have a general idea about the number of wells that'll be drilled, but we don't know the precise conditions of either production or where the fuel will get burnt under what conditions. So we'll look at it at a later stage. And then at the leasing stage, to the extent that there is environmental analysis, the agencies tend to say, well, we don't know exactly what the site-specific production impacts will be until a permit is issued, but we can't look at the big picture question of the role of leasing in climate policy at the individual lease stage. That's a bigger picture question, which they've dodged at the planning stage. And then typically, unless they're aggregated into very large projects, individual drilling permits tend to get approved with almost no environmental analysis at all, frequently through use of a document called a determination of NEPA adequacy, which concludes that these prior documents, which deferred site-specific analysis, cover everything. So my perspective is that there's a significant opportunity under existing law, although there certainly is pending legislation to alter drastically the statutory mandate that allows fossil fuel leasing on public lands. Under existing law, there is tremendous latitude for the agencies to consider the option not to lease. And I know I'm taking a lot of time, but I just want to point out one other thing. And the Department of Interior has taken a very significant step in this direction just this January with the Secretary's Order 3338, which imposes a partial, and perhaps we'll get into the gaps in this later, moratorium on the issuance of new federal coal leases under the coal leasing provisions of the Mineral Leasing Act, pending a programmatic environmental impact statement for the entire federal coal leasing program, which accounts for fully 41% of all U.S. coal, and actually, because most of this is cheap and low sulfur subbituminous coal from the Powder River Basin, a larger share of the entire coal-fired power generation in the United States. And in January, this order put a temporary moratorium on the issuance of new coal leases while Interior looks at three main problems. One is the question of fair return and fair market value on the leasing of coal. The second are problems with the reclamation of coal mines. And the third is the question of whether and how the federal coal leasing program can be consistent with the United States' climate goals. So that programmatic environmental impact statement process is projected to take about 3 years. Initial scoping, scoping is the initial phase of any National Environmental Policy Act process where the agency takes contributions from other agencies on the public of what the scope of analysis should be. That completed earlier this year. Some sort of preliminary document is expected around the end of the year. But one of our main goals is to see a similar both review and moratorium of the oil and gas leasing program, including for the first time some sort of systematic consideration of what that program means for meeting or not meeting the nation's climate goals and Paris commitments.
Anything to add?
Yeah, I just have a few points to add. So I thought maybe it would be helpful to sort of, like a law professor, let's start at the beginning with how did we end up with federal lands and why are we talking about them when it comes to the West? So if you look at the whole, I won't go into the history of the United States, but the 13 colonies, and then you have states that were created out of existing states, then you had states like Texas, which were owned or territories under other countries. So we have most of the federal lands being owned west of the Mississippi, west of Oklahoma, Texas. So much more federal lands concentrated in that western part. And there it was the realization of the federal government that they were giving away really valuable mineral rights, subsurface rights. And so here you have a movement too over time of the federal government giving away, or not giving away, but the transference of surface estate. So the surface estate, it's like the icing on the cake, right? And the cake, the subsurface, is what they would retain. So that's why the BLM and these agencies can manage either fee simple, so they own the brownie and the icing on top, so surface and mineral estate, or subsurface, or they can own just the mineral estate, they can own just the surface estate. There can be a severance. And the important thing to realize too when we're looking at this idea of energy development on federal lands is that's what was of value, right? There's a historical background, a foundation to these mineral leasing acts, is that that's where the value was with the mining, hard rock minerals, with water. The idea that it's not riparian rights, so in the eastern United States, we follow this, you live near the water, of course you have access to the water. In the West, where we needed water for resource development, for irrigation, for land, it was the right to take. So whoever has a Colorado doctrine, sometimes it's called, but you had this idea that you needed to put utility, there had to be a utility to resource. And so that's where you have this sort of development of federal lands, primarily in the West. And that severance of estates then, coming back to this regulatory statutory framework, is really about to access the subsurface, I need to have access to the surface. So in order to get the cake, I have to cut through the frosting. And so that subsurface becomes the dominant estate, and the surface is the servient estate. It's the estate that can be burdened by use. And then going on, I guess I just wanted to put into context the planning and leasing and the permitting stages. The planning stage, though, that's not in the hands of the energy user, right, or the industry developer. That's in the hands of the BLM. So that's a resource management plan. And those resource management plans are done by BLM regional offices. So the regional offices, every 10 to 15 years, are supposed to put these resource management plans into place. So that's the stage one of the planning process. And it's supposed to identify these issues under the multi-use and sustained yield platform. And that's under the Federal Land Management Policy Act. And that's the creation of this. There are multiple uses for resource. So the historical tendency to value resource extraction, mineral development, oil and gas leasing, coal, that has given way over time to recreational purposes, conservation goals. And so that is the idea of the multi-use and sustained yield. So that's the planning stage, the leasing stage, and the drilling or the permitting stage that Michael was referring to. Just a little bit of clarification too. Energy development includes renewable and non-renewable. So I know we've heard reference to oil and gas and to coal, but we should keep in mind that the BLM is also responsible for promoting and developing not only non-renewable, but renewable assets. And so they have solar facilities, hydroelectric dams, which falls sometimes under the purview of the Army Corps of Engineers, and also, I'm trying to think of solar, some wind, and then geothermal. So which are mostly located in California. So that's renewable and it's non-renewable under the BLM and under these processes. Under the leasing process, if we go back to sort of the coal lease and these various other lease, you receive a royalty. So the federal government receives a royalty, which is a cost-free share of production. So that's the benefit, right? It's a mutually sort of beneficial relationship, but like all forms of energy development, whether it's renewable or non-renewable, there are burdens in addition to benefits. So that's sort of the idea, and we can talk about the moratoria maybe later on.
That's great. Thank you so much. Good overview. Gives you a little feel for the regulatory and statutory structure that governs this issue area. So I want to bring it down a little bit closer to home because a lot of the way we see this issue play out is at the local level. So we're going to ask our panelists to talk about the way that local communities interact with energy development. And again, I think Monica's point is a good one. There's oil and gas and coal, and there's also renewable energy. We're going to ask the panelists to speak about what they've seen in their work from local communities regarding how they deal with energy development on nearby public land. So we often call these areas the wildland-urban interface, or the communities that live adjacent to public lands. And they have a particular voice in this conflict because it's happening in their neighborhoods. And we're going to move from this. This should be relatively brief, and then we'll move from this to try to highlight specific places of conflict and specific places of cooperation. But what do these communities deal with when there's energy development locally? And Michael, we'll start with you.
Certainly. I've, in my work, formerly at National Wildlife Federation, my work with tribal communities, and now at the Center for Biological Diversity, I've had a chance to spend time in some places and meet the people who live in some of the communities that are sort of at the heart of the public lands energy supply sacrifice zones that feed the power for much of the rest of the country. And this is my personal perspective. Those communities face both extraordinary benefits and extraordinary challenges. The few remaining coal jobs, although most of those are gone to automation, not environmental regulation, are very well-paying jobs, in rural communities. Oil and gas industry jobs pay really well and allow people to support families, in ways that the loss of many other industrial and manufacturing jobs has taken away from other communities. So it provides the opportunity to make a good living and support a family in some extraordinarily beautiful and tight communities among the public lands, places like Pinedale, Wyoming, in the Upper Green River Basin, or the North Fork Valley of Colorado, Vernal, Utah. On the other hand, these communities face some extraordinary air quality problems for such rural areas, levels of ozone, volatile organic compounds, particulate matter that, in many cases, Northeast Utah, Eastern Colorado, approach or exceed air quality standards. And, the tiny town of Pinedale, Wyoming has, worse ozone problems than many urban areas. The split estate issue, which a couple of my co-panelists alluded to, also creates some exceptional challenges for rural landowners and ranchers, where this legal concept of the mineral estate being the dominant estate that Monica explained means that you can own a ranch in somewhere like the Powder River Basin of Wyoming or the Piceance Basin of Colorado, but it turns out that the BLM actually manages the minerals, and though your family has lived there for generations, developments in hydraulic fracturing mean that geologic formations, which had not previously been a target for oil and gas development, are suddenly leased, and that dominant estate means you don't have ultimately the right to say no to that drilling and fracking rig coming in on your lands. And that's been the focus of many of the conflicts that Kathleen and the Colorado Oil and Gas Conservation Commission deal with in Colorado. But I also sort of want to, raise again, coming back to the climate side of things. There's an imbalance here in that these, local communities reap some of the economic benefit in jobs from energy development. Although bear in mind, a lot of that is, accrues to the companies who do not necessarily have a local presence. The climate burden of the federal fossil fuel program, which is, to understand, is about 25% of total U.S. greenhouse gas emissions. That's 3 to 4% of global emissions. This is a staggering amount. Those are borne not just nationally, but globally. So, my perspective here is that it's time to start talking honestly with those communities about the fact that business as usual is not sustainable if we want to have any hope of meeting Paris targets, that there needs to be a managed transition, and there needs to be a lot of thought given to what's the future for these communities. Obviously, renewable and sustainable infrastructure has a huge potential for job creation, but it's not going to necessarily be concentrated in the same, in particular coal-dependent communities that are already being affected by the beginning of the end for coal.
Thanks, Michael. Anybody else want to jump in? Impacts to communities in particular we're interested in.
So I think one of the privileges of serving within the federal government is that you get to interface with these communities very directly. And I'm really proud of what this administration has been able to do on the climate front in particular. I think that there's an incredible amount of energy being spent by advocacy groups and groups that are really sort of grounded in data and conservation groups that are helpful in being able to move the needle so that we actually have the legal mechanisms to change some of the very old statutory requirements that we are currently working under. So I'm really encouraged by that. I think a few examples that are worth lifting up today, the Arctic. I got a chance to go to Barrow, very remote. It was March, -30 below, coldest I've ever been in my life, and I went to law school in Vermont. And just being there with the villagers and meeting with a very small contingent. It was about 6 older gentlemen, and they represented the Eskimo Whaling Commission for Barrow, for the village of Barrow. And listening to them tell their stories about having to move the village and how they anticipate moving the village again in a few years. 3 was their best guesstimate at the time because of sea level rise, and referring to the ocean as their garden and really understanding subsistence living firsthand. So that was, again, an honor and a privilege, and that was in thinking about whether or not to explore drilling in the Arctic, and of course the decision has come down on that, fortunately. I think another great example is I've spent an incredible amount of time in coal mines and dealing with communities in Appalachia and in the West, and really understanding, Michael mentioned these are good paying jobs, and folks having to pivot when we're watching the devastation of this industry. I mean, we're watching unprecedented bankruptcies in coal, oil, and gas, and I think we anticipate that the oil and gas industries will be able to recover in a way that the coal industries are not anticipated to be able to recover. And figuring out what can be done from an economic development perspective to be able to translate these skill sets where you can have a diploma maybe and be able to make $80,000 a year. So we've spent a lot of time trying to work across party lines. We introduced, working with folks like Hal Rogers of Kentucky to introduce the Reclaim Act. There are tools that we are hoping will get traction to be able to basically use $1 billion over the course of 5 years to create economic stimulus in some of these countries, some of these states rather, based on their historic coal production formula. So basically what they have given to the country, allowing them to pivot. I also had a chance to spend some time in Hawaii and listen to the community's sort of initial reactions to the prospect of offshore wind there. And offshore wind is another renewable that I think is important to lift up because we, for the first time, have steel in the water in Rhode Island, and it's an incredibly exciting opportunity to see what this country can do to harness winds off of our shores and have domestic supply chains that can hopefully employ many more folks to come. So I'm personally very encouraged, and I know that I've sort of had a chance to go and see the wizard and peek behind the curtain. And I would encourage the push to from external groups, and now that I am on the outside, to continue. But I do think that we have to appreciate that, you know, things like CEQ moving forward with guidance and sort of crystallizing the importance of assessing greenhouse gas impacts are important, and it will be a process before we have the right tools, because these energy development, and I know we respectfully disagree, but these energy development bureaus are responsible for royalty collections that finance the federal government. So as we go through this transition, it is a process of weighing the balance, and the communities need to be compensated and need to be able to inform the process because these are their homes.
And if it's okay, I'm going to add just a touch more. At the state level in Colorado, we've been paying a lot of attention to these coal communities because they have been very largely impacted by the decline in coal. And of course, it's not just the regulatory system, but it is the market. It's the price of natural gas. It's the resources that are available. And so there's a lot of factors that go into the decline of coal, although it really has been a very quick decline. And I actually was out in the North Fork Valley. Michael and I were there for very different reasons a week ago, meeting with representatives from the coal mines and representatives from the communities. And it was actually a meeting pulled together by the BLM. Staff from the Washington, D.C. office had come out, those that are working on this programmatic environmental impact statement for the coal leasing program came out to talk to these coal miners and the representatives from the communities to hear how the decline in coal has affected those communities. And we've gone from 3 coal mines in this North Fork Valley that employed over 1,200 people down to 1 coal mine that employs about 220. And that's just in the last 2 years. And so it has been a very quick, very precipitous decline. The impacts on the local economies are severe. And part of the challenge, too, in an area like the North Fork Valley is that Delta County is primarily federal land. And so there's not a lot of other things that they can do there because they're limited on what they can do. The communities can't expand onto federal land. They're sort of limited. And so they're thinking about tourism and recreational opportunities, but at the same time, those don't bring in that same tax base that the mineral extraction does. And so those are real challenges for the communities. At the state level, we're trying to figure out how to provide resources. How do we work with the communities to figure out where they want to go next? And so it has to be driven by the communities, though. We can't come in as the state and say, well, you guys are now going to be trained as solar panel installers. These are coal miners. Coal mining has been happening since the late 1800s in this area, and you don't just change that culture overnight. And so it's been a real challenge. I think on the oil and gas side of things, when you're talking about the more rural communities, we see a lot of engaged communities. I think about the area near Aspen, Carbondale, in the Thompson Divide, and those communities are very, very active and have actually played a very significant role in where leases have been approved or withdrawn, where oil and gas development is happening. And then I think the other thing worth mentioning at this point is the technology. The technology has changed so much. What we used to see is those, in the vertical development times, was 1 well per 40 acres, lots and lots of roads connecting those different well pads. And now you have much more concentrated development where you have one pad that's larger with more development, but fewer access roads, certainly there are arguments to be made that the sort of the impacts in one area are greater than the sort of dispersed impacts that you'd have if everything was spread out. But it's I think from a wildlife fragmentation, from a interacting with recreational resources, that has really made a big difference in being able to access more resources from one centralized location.
I just wanted to add just a few points, just in the interest of time. I'll try to keep it quick, but just going back to the importance of the dominant estate, right? This idea that the mineral estate can be accessed through the surface estate. So that's an important concept. Otherwise, if I give you, right, the cake, and I say, you can't touch the frosting, though, to get through it, it's worthless. Your property becomes worthless. So that's the sort of historical notion, and it's an old notion, right, through sort of English law, of this idea that you can have a dominant right and then a burdened surface estate. But I also wanted to point out just this idea of income, and we've talked about tax revenues, but we talked about the royalty. So remember the cost-free share of production when it comes to coal or oil and gas. So what the royalty interest owner receives in return for giving up their mineral interest. So here what the federal government is going to give you if you sign a lease, they in return get a share of the royalties. That is yours, right? Federal lands are held in trust for the people. So it doesn't go to just the local community. That's almost $99 billion that's coming in that goes through federal programs, that goes to all of us here. So that's an important source of revenue that goes to the American people, to infrastructure, and to programs. The additional streams of revenue that my colleagues were talking about too, there can be benefits to the local community, as Michael pointed out, so in terms of jobs, whether it's directly or indirect, and various other aspects of that. But the royalty stream, that's an important stream of revenue to the country. And I think I'll leave it at that just so we can move on.
Great.
If I might just add just a little bit to what Kathleen was alluding to about the North Fork Valley. This is a really interesting sort of case study where a lot of these things overlap. It's been coal mining towns since the 1880s, but as Kathleen noted, 2 of those 3 mines have closed down, and these communities are not unified. At the same time the state was meeting with the coal mines, I was out there in Forest Service roadless areas backpacking with other locals who are fighting desperately to keep the wilderness quality roadless areas they spend time in and love deeply from being bulldozed for methane drainage wells to vent methane straight into the atmosphere within a roadless area under a exception to the Forest Service roadless rule specifically for coal mines in the North Fork. That also, is sort of at the center of all these things because that rule is actually on its second time around, having been overturned once in the courts by a very significant decision that said for the first time that if agencies are going to quantify the economic benefit of fossil fuel development, they also need to qualify the climate cost of that harm. The North Fork Valley is also seeing something of a bloom in organic agriculture and winemaking as the coal jobs go away, but it's also proposed for leasing for hydraulic fracturing, for oil and gas development that would result in hydraulic fracturing. That's been suspended a couple of times in light of a lot of intense opposition from within that valley, and the BLM is currently in the process of a planning process to sort of try and reweigh what's the role of coal, oil and gas, and recreation and intact lands in the future of that valley.
Thanks. We had a couple more questions we were going to, and I say this because I think we're going to jump straight to audience questions because we're running out of time, but we were going to, at this point, move into discussion of highlighting where the areas of conflict and where potential cooperation and partnership opportunities might lie. So I'm going to ask the audience to try to draw out those themes through your questions. If you have them, I want to make sure we have time for questions. If there aren't enough questions to carry us, I'll come back to the panelists and we'll see if we have time to get there. But we did hope for some questions. Do we have a microphone out here? Somebody managing the mic? Jonathan, thanks. Can you bring it? I think there's a question right here in the front. Thanks.
Hey, my name's Matt Maroney, first year MEM. My question is this. In the 21st century, do you feel like this patchwork of laws, some dating back to the 1880s, are adequate to manage energy? And if no, then what would be your policy proposal for a new law that would take care of some of the shortcomings that currently exist?
I'm going to take just the first stab at this being a law professor. It's very exciting when you talk about new laws and getting rid of old laws. And so I'm going to give you the theoretical, right? Yes, it would be nice. The reality that it just won't, it is very unlikely to happen. So there's just several reasons for that, right? So we're a common law system, and the common law evolves, right, through we have a sort of hybrid of legislation, of regulation, and then we have the courts that interpret this, and that's the three branches of government. So, and these federal agencies usually fall under the executive, and sometimes they have sort of quasi status. So it makes a sense, right? It makes sense that some of these laws were drafted a long time ago. They were passed a long time ago in a different environment. But the difficulty then is, and you've seen the sort of climate in Congress, it's very difficult to get consensus on passing major pieces of legislation. And that sort of beautiful breakthrough of the late 60s NEPA and 69 and Clean Water Act, Clean Air Act, this sort of big decade of these major environmental legislations, that would be so hard to do now in this political climate. And I might defer to Brandy on that.
No, well done. It's a tough question. One of the observations that I would make is that there has been an inordinate amount of time spent by bureaus that never before were sort of in the business of making rules, trying to develop and pass rules. So one example is the stream protection rule, formerly known as the stream buffer. I mean, this thing has taken on so many different iterations, and at its core, it is now a final rule after almost 6.5, 7 years, where we finally got it proposed, huge hurdles cleared, and now it's final with basically the Office of Management and Budget. This is a rule that has had a lot of you just have not been able to get folks to agree on the impact that it could potentially have. The new rule I'm encouraged by because it actually for the first time will require the recording of certain data points, water level impacts, all the things that you care about, everything from the salamander, you care about the critters, you care about the impact to public health, you care about how close these things, because coal mines are usually, I've seen a home 20 feet away from a coal mine. So the impacts are tremendous. And as these operators go through a lot of fiscal challenges, reclamation is incredibly important. But getting the rules in place that actually require operators to uphold those obligations are absolutely core to being able to have other groups speak out and ask the administration or these federal agencies to do more. That is the hook. So we have had, there's a venting and flaring rule that's now underway. There are a tremendous amount of rules. We've become sort of like this rule-making agency, frankly, to address the observation that you made in your question, which is how do you supplement for antiquated laws, statutes, and regs? And I think it's a process, and it's not going to be fluid without continuity and administrations holding true to those core principles. So the programmatic environmental impact process that was underway, the scoping document will essentially set the table for what we should do with coal in the future. But that has to be truly taken on by whoever is president next. And, I think we can cast the die based on what we predict will be priorities for who could potentially become the next leader of the free world. But it will require a huge process to figure out what are the appropriate calculations in determining the market value of coal. How do you adequately, assess the climate impacts, greenhouse gases, social cost of carbon? I mean, what vehicle are we using without a carbon tax that's fair to the people? So I'll leave it at that.
I would note that there is, there was legislation proposed this year and last by Senator Merkley and Representative Hoffman, respectively, that would sort of cut the Gordian knot and of these various antiquated statutes by legislatively simply ending federal fossil fuel new leasing, both onshore and offshore. Obviously, that's not going to pass in this current Congress, and just speaking for myself, a Congress that would pass that would presumably be also a Congress that would pass comprehensive climate legislation. But I've
Budget or a budget.
Yes. But I've written a lot and advocated for that. There are, even under these antiquated statutes, there are existing mechanisms that, again, assuming continuity of administration and sufficient will, that let the executive branch end new leasing, and those are specifically Section 204 of the Federal Land Policy and Management Act, which governs withdrawals of lands from particular aspects of the public land laws for a period of up to 20 years. And then for offshore lands, which we have not really talked about much, but are a huge portion of the public lands energy supply, Section 12A of the Outer Continental Shelf Lands Act, which vests the president with unparalleled discretion to withdraw submerged lands of the Outer Continental Shelf from leasing. So, at least for new leasing, there are mechanisms available to a willing administration under the existing laws. As Monica has aptly pointed out, once leases are in place, there is this dominant estate and a property right in the lease. So the question of how to deal with those is a much more difficult one, because under virtually, any 2 degrees Celsius or 1.5 degrees Celsius carbon budget, unless the United States gets to take the entire world's carbon budget, we not only can't issue new leases, we can't burn everything that's already under lease. So there's so much to talk about here, but the venting and flaring rule, which Brandy mentioned, is incredibly important initiative that starts to address one of the really significant issues with existing leases, which is the venting and leakage of methane, a vastly more powerful greenhouse gas than carbon dioxide directly into the atmosphere.
Well, I wrote an article on venting and flaring in North Dakota and the Bakken, and I just wanted to point out too, if you have to look at this transaction, right? This sort of relationship, it's a quilt, or not even a quilt, it's more a tapestry. Yeah. And there are threads that weave through this tapestry of energy development on federal lands, and that includes preservation, conservation, environmentalism, but also economic development, resource management. There are social rights at issue here, and it's very complex. And so if I'm just to pull a thread out and say, no more oil and gas leasing. That's it, we're not issuing anymore. I pull that thread out, I'm going to unravel a large part of this tapestry. And that the same goes for any of them, right? I decide, well, I'm going to discard an analysis of environmental impact. That unravels the tapestry. So that's the difficulty here. I know Michael's talked about this, not leasing oil and gas lease, but the reason I think personally, why it's easier to do a moratorium on coal leases really haven't been issued since the 70s. There really isn't a lot of coal going on. After natural gas came into play, natural gas was cheaper, and especially now with commodity prices, far more economic to produce. And so that really is sort of the, coal has just become the sort of unwanted child, unfortunately, of the energy family. So it's very easy to discard coal, not with oil and gas. 80%, I think it was the Office of the White House Science and Technology, it came out and just said it's got to be an all of the above energy strategy. Right now, 80% of the US energy supplies come from hydrocarbons. And petroleum, oil and gas, and oil, specifically crude oil, 70% of that is used for our transportation. So getting rid of something, getting rid of an energy source that gives us security of supply, and being the largest producer of oil and gas and liquids in the world, surpassing Saudi Arabia, that gives us an incredible amount of geopolitical security and stability. And that all translates into lives, into economies of scale, into these smaller pieces, these threads. So I think we just need to be very cognizant of the fact that it's not just a simple, let's turn off the spigot, and look at it in terms of a supply, demand, and effect relationship. So the Keep It in the Ground movement, which is so, it's important to have community activism. That's an important part of this democracy and what makes this country so incredible. And having that Keep It in the Ground, it affects the supply. Let's turn off the supply, let's turn off the leasing. When I decrease supply, from an economic standpoint, what does that do to price? It increases price. And so now if I'm importing from other countries, I'm going to take oil and gas from other countries, whether that's Canada, and I'm going to do that through oil sands or conventional oil and gas in the Western Canadian Basin, or I import LNG from other countries, Venezuela, right? What am I replacing? I think if you're going to look at this equation, you need to look at the demand side. Why aren't we addressing consumption? Not just energy efficiency, but energy consumption. And so even ExxonMobil, Rex Tillerson again in July said, carbon tax. Why don't we have a carbon tax in place? British Columbia, provinces in Canada, Europe, we have a carbon tax, and the oil and gas industry has said at least that's a known, right? It's a known quantifiable risk that they can address. So I just wanted to point out the sort of complexity.
Thanks. I want to make sure we have time for a couple of other questions. See a question over there behind you?
Hello, my name is Oscar. I'm at both the forestry school and the business school. I would love to hear your perspective on the Dakota Access Pipeline, because it's an example that connects so many of the missteps that you've been talking about so far, and so many of the interactions with public lands as well.
Anybody want to take that one?
I am no longer with the Department of the Interior. I will not take that one on, but I do defer to others who would. I think at its core, it's another example of the unique role that the Bureau of Indian Affairs has in all of this, which is also part of the Department of the Interior's, one of the other agencies within their umbrella. I think the community impact and the voice that communities have is imperative. There is not an organization, but sort of it's an interagency working group that focuses on environmental justice, and it's frankly often perceived as being a bit disempowered, and it's now become much more robust in the last few years by pulling in the actual cabinet member and chief of staff for that particular department, because it allows issues like this to work from the bottom up to get to a point where hopefully what happened in this instance does not have to happen, because they're able to kind of elevate, like the Bayonne Bridge, other examples where there just has not been enough engagement from the community. I think you want to get in here, but these are difficult issues, and no one's taking that away from the assessment that has to be made. I do think that outside of this unique case, the importance of congressional cooperation when you're dealing with all energy development tensions. I mean, I was sort of being, joking with Michael about them being able to also pass a budget, but we've gotten a lot of critiques, of the administration about the use of tools like executive orders. So I mentioned regulations as a tool, and I just want to make sure that we're being clear about the different vehicles that can be used, because these are all things that you all at some point will use when you're out in practice in your respective fields. But I think congressional cooperation with an administration makes the path forward to making huge transitions to adjust to the impacts of things like climate a lot easier, and that's been tremendously difficult. And so I'll leave it to others to chime in on the pipeline, but.
Well, I can just address it very quickly by saying your question is a very good question. The Indian law and resource development in Indian country, it brings in another aspect of Indian law, so there are sovereignty issues associated with it, which is why it's difficult. I have 2 colleagues at the University of Oklahoma who study and teach in the indigenous peoples space, and I'm happy to give you their contact information if you wanted to follow up with them. But it's it's a bigger question just because the tribes are involved.
Yeah, it's when we had a pre-meeting of this group over the phone to talk about this panel, we asked the question of each other, do we want to also cover tribal issues? And we all decided probably not, because it's too much to try to do in this length of time. We'd have to introduce all of these other parameters and aspects of law and jurisdiction and sovereignty and authority. So it's a bit of a different animal. I think it's a great question. It's very timely. Let's move on. Any other questions in the audience? Sarah Rose?
Hi there. Just to bring back the theme of cooperation, which could be seen as a synonym for collaboration as well. I'm wondering, first I'll say, why should we collaborate or cooperate, and how do we maintain the integrity of whatever those values or goals are? Speaking of Pinedale, Wyoming, there were efforts to engage the community in improving the air quality situation that had a stakeholder process and ongoing meetings, but I think it ended in a lot of those people feeling like they weren't truly heard and that their voices weren't incorporated into decision making. So I'd love to hear you muse about why we should collaborate, because that might help us figure out how to do it well in the first place.
One other just initial sort of reaction to that is I cannot tell you how important it is to hear from people on the ground. I mean, I spent a lot of time out at public meetings, out in the community, and getting feedback from different advocacy groups when we were planning for public meetings with the 4 bureaus to kind of understand what their feedback was. And using the stream protection rule as an example, we heard from groups that they were concerned about intimidation tactics from some of the coal operators. We took that to heart. We saw some of the coal operators, employ their staff to come to the public hearings, which means you get a robust turnout. So, there's not a judgment on that, but we were mindful of that. So then you think about, do we shift time so that it's not from 9 to 5 so that people, when they get off work, can actually attend? So I would say being able to feed the information to the folks that are trying to make sure that your voices are heard in the process is important. Staying in the conversation is the only way to be heard. So, from a regulator's perspective, it is absolutely core and critical, or else you put a lot of time and energy into a robust NEPA process, and then it fails at the tail end because there's discourse that just has not been flushed out in the community, and they're against the project. These things live in the community, and it's important that they're heard early on.
And if you don't mind, go ahead. My entire universe is engaging stakeholders and making sure that we've got the right people in the room. And you're always going to have people who don't feel like they've been heard because their issues haven't been resolved. And I think one of the things that we see at the state permitting process, we have a lot of public comment opportunities. We have a lot of, we've done a lot of efforts to make sure that the information that we have is transparent, that people have access to the state processes, either directly by picking up the phone and calling any one of us, or through a program that we call the Local Government Designee Program, and people can go, local governments can get involved in the permitting process directly by having their local government designee request a hearing or provide specific comments on a permit. And I think one of the things that the state level that we do, and any operator on federal land has to get a state permit too, so they go through this process regardless. If they get concerns from the public that are, legitimate concerns about health or water or whatever the issue is, the state makes the operator address those concerns. And if there are things that can be done to mitigate, if there are things that they can move, if there are, ways they can change the layout of the pad to not have noise or change the timing, whatever those restrictions are, those get implemented in that way. And so I think that the public outreach and the public involvement is imperative. I also think that it comes down to education as well, because there is so much misunderstanding, and there's a lot of mistrust too. We've done a lot of public meetings where we've wandered around the state and listened to concerns, and half the time people say, well, we don't trust the information that's coming out of the regulatory agency. It's okay. And so how do you get that information to those people? And so we work a lot with our sister agencies to make sure that people have the information that they need, that if they have concerns, they know where to go. Are you going to have people that are upset? Always. It's natural resources. There's so much passion involved in every single aspect of natural resources. But I think that giving people the opportunity is imperative in making this process work.
Kathleen, I think what you just said was so, it's very impactful, what you talked about trust. And I think that's the big gap that's happened here. It's the elephant in the room that it's hard to have a dialogue with each other if we don't trust the source of the information. And for some reason, I guess I'm not going to be able to talk about it in a minute, but we've had this conflict, and it is as if you're either on the side of the environment or you're on the side of big industry. And that's not the case, right? We've already talked about and discussed how complex and interwoven these issues are, but the idea of who do we trust and where do we get our sources of information from? And I think, Josh, Lisa, I can't remember if it was at NDEL, you had that great panel that talked about we have sources who are more on the one side of the spectrum. We have sources that are on the other side of the spectrum. Where is the middle ground? Where's the Walter Cronkite of information, People are waiting for that source. And that quick dissemination of social media where there's no fact-checking or there's little fact-checking, and it's very quickly dispersed without any kind of repercussion, right? Like, this isn't true, this isn't the case. It is such a difficult question, and I think that just impedes the collaborative process or collaborative stewardship that we would like to have.
Absolutely.
Thanks.
I just want to rain on this collaboration parade just a little bit, because in my experience, usually collaboration is just a buzzword that in reality means capture. That
You really are glass half empty.
as you alluded to with the failure of the Pinedale Anticline Working Group, industry has astronomically more money, resources, political influence, connections, day-to-day contact with the agencies, that they can stretch these processes out forever, maintain uncertainty, maintain the status quo, and simply outlast the volunteer citizens and handful of NGOs. And on the climate side, I don't feel there's currently a lot of room for collaboration. Maybe that will change, but I think, this is, this is not sort of a, this is not a win-win situation. This is, a social movement to make clear that fossil fuel extraction has lost its social license, and that that requires substantial changes to business as usual. So I think there are some good examples of collaboration in addressing site-specific impacts, and I'd like to point to the BLM's Master Leasing Plan program, which has done a good job of, in some particular places like Moab, Utah, South Park, Colorado, bringing together industry, the state, and citizen groups to, to come up with some collaborative solutions to the surface impacts, but collaboration does not make the kind of drastic emissions cuts that we need.
I just want to just point out, though, that it's not an us versus them. It's not industry. All industry are bad actors. That's not the case. I mean, even if you look at corporate social responsibility, companies are made up, whether they're publicly traded, it's the shareholder, it is the public, it is the teacher's pension plan, it is the diocese, right? It is the public. If they're privately held, they're still in the form of partners, that they are people. And usually, too, with local offices, there are people who live in the communities, who have to interact on a day-to-day basis with people who are their relatives, who are their family members, et cetera. But even on a broader scale, companies want to do a good thing economically. Why would you want to incur cost, right? Why would I want to incur environmental cost and environmental harms? It doesn't make sense from an economic standpoint, nor does it make sense from a corporate social responsibility standpoint. So I maybe take issue, at least portraying it as sort of a battle. The battle ideology is not going to win the war.
Yeah, I think the frustration and the passion that I hear today is exactly why staying in the conversation is so important. And I think around climate in particular, I will say the frustration when you are trying to weigh the balance between all of the different stakeholders that you're hearing is you have to be able to support it legally. And if you're not able to have the right vehicle, whether it is legislative, regulatory, an executive order, you need a hook that will stick, especially for something as important as climate. And so we are in a transition period, which is why I think you are all in for an incredible ride, I think, in terms of what your careers will do to pivot and be able to hopefully address some of these concerns from a variety of different angles. And it's important that you stay in the conversation. This is the line I used with every stakeholder, whether it was, someone with big money bags or someone without the same amount of resources. They had my number directly, and my clear ask was, I know you are frustrated. I need you to stay in the conversation because we were listening. And it's frustrating when you don't have the solution in hand, but you do move the needle. And I think we have never had a president that has spoken to climate as we have in this president. And it's something that I think we will miss. And I think it's something that we need to make sure we find the right way to effectively advocate to moving the needle forward for future generations.
I think on that note, I'm going to call this a wrap. We do have a reception outside. This has been a really exciting, passionate, engaging conversation. Our panelists will be here for at least half an hour. We have some wine and snacks outside, so please join us, and we'll carry on the conversation informally in the lobby. Thank you.